Maternity protection has been the subject of international labor conventions since the ILO first began adopting conventions and recommendations back in 1919. 3 conventions have been adopted in the past some 100 years, numbers 3, 103, and 183, respectively in 1919, 1952, and 2000. These instruments focus on leave from work and cash and medical benefits for women workers in the case of maternity. They also require protection to ensure that women will not lose their jobs simply because of pregnancy or maternity leave. Such protection not only ensures a woman's equal access to employment, it also ensures the continuation of often vital income which is necessary for the well-being of her entire family. Safeguarding the health of expectant and nursing mothers and protecting them from job discrimination is a precondition for achieving genuine equality of opportunity and treatment of men and women at work, and for enabling workers to raise families in conditions of security. Now, no international labor convention addresses the possibility of paternity protection, at least not as such, or at the level or scope of that suggested for maternity protection. The newest ILO recommendation, number 191, on maternity protection, does indeed suggest that adoptive parents should have access to the system of protection afforded by the convention. And there are countries around the world that recognize the importance of paternity in the context of the world of work, providing certain benefits and protections. But again, there is no binding international labor law on this subject as such. The issue is, however, a real one. It is monitored by the ILO along with related national developments. It is also captured within the concept of workers with family responsibilities, where it is recognized that family responsibilities, including paternity, should be accommodated in the world of work and not threaten employment and occupational opportunities. So although international labor law does not grant specific binding paternity benefits in cases like that we are looking at here, there are principles and rights established and recognized internationally that could be called into play domestically to argue this case.
Now, we've advanced from the basics of access to instruments texts in the norm lex, but in this particular case we just want to look at one other particular instrument, and that would be the recommendation that's been cited to us. To find recommendations, you use this recommendation link on the left-hand side of the norm lex, and we would want to find the recommendation on maternity protection. Let's look by subject just to see where that recommendation falls. And in fact, there is a category of maternity protection. And there it is, and you see the maternity protection recommendation of 2000, and we will be looking for that provision having to do with the potential for adoptive leave, and there we see it, paragraph number 5, or subparagraph number 5. To go further and learn more about what NormLex can offer us, in this case we would like to see the outputs of the supervisory bodies. Why? Because we know that there's not very much in the texts of the instruments, that is conventions and recommendations, that we could rely on in our domestic case. So perhaps the Committee of Experts has said something that might be particularly supportive. We would go to the area called Supervising the Application of International Labor Standards, click on that, and we come to the possibility to search comments by the supervisory bodies. And this again is essentially the search mechanism that we see by clicking here. What we're going to look for in this particular case is two lines of research. The first is to see where paternity benefits figure in comments having to do with application of the Maternity Protection Convention. So to do that, we would be looking for the subject of maternity protection, and we would be looking for comments having to do with paternity. And let's see what we are able to turn up. There are 9 comments found. One thing to note immediately is that we searched for all periods of time, that is, all committee of experts comments, not only the comments that are currently pending. So you can see that there are some comments back as far as 1994 that make use of the word paternity. So we're just going to click on all of them and see what they have to offer. If you look carefully at these results, you will see that the committee of experts in each case is reporting the information that it has been told by the relevant government in the government's own reports. It has not made a judgment about the relation of national paternity protection relative to the law. In these cases, the committee of experts is observing national law as a fact, that is, that it exists, without observing its compliance with international law. And that is, of course, because the conventions on maternity protection do not oblige paternity protection. So the committee of experts is simply noting that a development has occurred. You can do this exercise yourself and read through these 9 comments, and you'll see that this is the case. Even if we look at the observation involving Portugal, and let's see if I can find that quickly. I'm looking quickly here. We see this is a case of satisfaction. Now this is the most positive thing the committee of experts is able to say about the development in the country. And you can see that in this case, satisfaction is noted following the adoption of a legislative decree bringing the legislation into conformity with the provisions of the conventions which seek to ensure benefits provided out of social assistance funds to women workers. And that's because it's about maternity protection. But if you go on to the next phrases, the newly adopted decree strengthens social protection in case of maternity, paternity, and adoption. So there's an improvement in relation to paternity as well. But the satisfaction has to do with compliance with the committee of experts' previous comment having to do with implementation of this provision of the convention. Now, if we were to pursue another line of research, that having to do with discrimination, let's quickly bring that up in NormLex. We're going to reset the search mechanism. We're going to search under equality of opportunity. We're going to search in this case only for pending committee of experts comments, that is, comments that are currently outstanding and waiting for response from the relevant governments. And we're going to search again for the term paternity. Find, and 12 comments come up. I'll open all of these quickly. Now, of course, I've done this previously, so I know what the results are. And so I'll call your attention to, in particular, the case of Mauritius, where paternity leave is required for male workers who are married upon the birth of the child. Let me find that comment. Here. The comment involves the Workers with Family Responsibilities Convention, and what the Committee of Experts is doing here is observing that the national law provides a benefit for married men upon the birth of their child, paternity leave. But the committee notes that because the provision does not require paternity leave for unmarried fathers, the provision discriminates on the basis of marital status. Now, this is potentially something that could be argued in our case. This analysis might be useful in that it's possible to argue that discriminating against men in the granting of different benefits relating to maternity amounts to discrimination on the basis of sex. In any case, the argument along these lines might be made. Whether it's successful could be debated, but we leave that to another discussion. What's interesting is that the Committee of Experts brings up the point and asks for information on it. We can also look at the comment on Moldova involving Convention 111. Looking at the subject of paternity leave, the committee notes with interest, that's also a positive indication, that a change in the labor law introduced for the first time the right of fathers to take paternity leave, regardless of whether their spouse has taken maternity leave. We can use this case to show one more feature of the work of the ILO, and that is the technical work that the office does in promoting international labor standards, promoting development of labor law, and sharing information among ILO member states. Of course, in the work of the Committee of Experts, this is done through general surveys. So if we were to look for a general survey on the subject of maternity protection, we could see that there is none, at least back to 1985. If we were to look a little bit further, searching inside the ILO website for maternity protection and paternity protection, we come quickly to an interesting report, a law and practice report. Now, what's important to notice about this particular document is that it's not a document produced by the ILO's supervisory bodies. This is a document produced by the ILO Secretariat, which is a collection of law and practice on both maternity and paternity protection around the world. And this is simply a very informative, very useful, potentially, report, which could very easily contribute to the argumentation of our case domestically through a comparative labor law approach.